Hello everyone, and welcome to this episode of, well, let's be honest, this isn't really an episode of anything. It's more like a frantic attempt to cram some vital legal knowledge into your heads before you accidentally agree to let a police officer search your car for funsies. Over the next few minutes, we're diving headfirst into the murky waters of New Jersey law with a countdown of 10 recent cases that have dramatically reshaped the legal landscape, specifically when it comes to your rights regarding search, privacy, and even how long the state can lock up a teenager for stealing a bag of chips. Okay, maybe not that last one, but it wouldn't be that far off. The point is, each story highlights a key rule that impacts your everyday rights. Whether you're a law-abiding citizen or, well, let's just say someone who occasionally forgets where they parked their car after a particularly lively night out. Because we're all about public service journalism here, or at least that's what we tell ourselves when the tax man comes knocking. We'll break down these complex legal cases into bite-sized chunks that even a toddler hopped up on juice boxes could understand. Don't worry, we won't be using any big words, just a healthy dose of sarcasm and enough righteous indignation to make a Supreme Court justice blush. So, buckle up, dear viewers, because things are about to get legal up in here. And by legal, I mean we'll be talking about the law, not, smoking whatever it is the kids are calling it these days. This is important stuff, people. Picture this. You're on a business trip unwinding in your hotel room after a long day of, well, whatever it is people do on business trips, expense reports, PowerPoint presentations, inventing new and inventive ways to steal office supplies. The point is, you're in your jammies, halfway through a bag of chips, when suddenly there's a knock at the door. It's the police, and they want to have a little chat with the person staying in your room. Now, you might be tempted to think, well, it's not my room technically, so come on in, officer. But hold your horses, cowboy. State v. Carter established a crucial legal precedent. Even if the hotel staff gives the cops the green light to barge in, they still need a warrant or your explicit consent to enter. Why? Because the Fourth Amendment protects people, not places. So unless you want your relaxing evening interrupted by a bunch of cops rifling through your things, remember those magic words. Do you have a warrant? You have a... the open road, the wind in your hair, the radio blasting your favorite tunes, the flashing lights of a police cruiser in your rearview mirror. Joy. Now let's say the officer approaches your car, smells that new car scent mixed with a faint whiff of what might be oregano. He decides to call in his trusty canine partner. Here's the thing, State v. Sims made it clear that cops can't use a dog sniff as an excuse to turn a routine traffic stop into a full-blown episode of America's Most Wanted. They need a new, reasonable suspicion to extend the stop beyond the initial reason. So unless that oregano scent is accompanied by a baggie of suspicious green leafy substance in plain view, that dog better have a darn good reason for drooling all over your upholstery. Otherwise, you're free to drive off into the sunset, preferably while listening to something other than Bad Boys on repeat. Imagine you're cruising down the highway, windows down, music up, living your best life. Suddenly you get pulled over. Maybe you were going a little fast, maybe you were singing a little too enthusiastically along to Britney Spears. The point is, you're now engaged in a delightful conversation with a police officer. He asks if he can search your bag. Your friend, in a moment of misguided helpfulness, or perhaps just to get the whole ordeal over with, says, "Sure, go ahead. It's not even his bag, it's mine." Well, guess what? State v. Smart says, "Nice try, buddy." The court ruled that only the actual owner of the bag, or someone who has clear control over it, can give consent to a search. Your overly helpful friend just earned themselves a one-way ticket to the land of I told you so. Remember, folks, when it comes to your rights, it's always better to be safe than sorry. And also, maybe find friends who won't volunteer your belongings to law enforcement. The American justice system, famous for its fairness, its compassion, and its tendency to occasionally throw the book at teenage offenders. Thankfully, cases like State v. Comer and State v. Zarate are challenging that last part. These landmark rulings dealt with the issue of sentencing juveniles to, basically, life in prison without any real chance of parole. The courts decided that this practice violates the Eighth Amendment's ban on cruel and unusual punishment. Essentially, the judges acknowledged that young people, even those who make serious mistakes, have the potential for rehabilitation and deserve a genuine opportunity to turn their lives around. It's a powerful reminder that justice shouldn't mean tossing away the key, especially when it comes to kids who are still figuring out who they are and, what kind of hair gel works best for their lifestyle. In this digital age, it seems like everyone's tracking our every move. Our phones, our smartwatches, our internet search history, even our refrigerators are probably judging our late-night snack choices. But when it comes to law enforcement attaching a GPS tracker to your car, well, State v. Shaw drew a line in the sand. The court ruled that even if your car is parked in public, sticking a tracking device on it still requires a warrant. Why? Because as much as we might complain about our privacy being violated by targeted ads for orthopedic shoes, the Fourth Amendment still guarantees a certain level of protection from unreasonable searches. So unless the cops have a warrant signed by a judge, they can't just slap a tracker on your bumper and call it a day. They'll have to resort to more old-fashioned methods of surveillance, like, actually following you. Now let's talk about a topic that's about as comfortable as a pair of jeans, 2 sizes too small strip searches. State v. Andujar tackled this sensitive issue head-on, and the ruling was clear. Cops can't just go around demanding to see people in their birthday suits without a darn good reason. The court emphasized that strip searches are incredibly intrusive and require either probable cause or a clear policy violation to justify them. In this case, the search was deemed unlawful because the officers didn't follow proper procedures and lacked sufficient justification. It's a crucial reminder that even those tasked with upholding the law can't disregard basic human dignity and the right to privacy. So, unless you're auditioning for a nude beach documentary, remember that you have the right to keep your clothes on. Thank you very much. Remember that classic children's rhyme, knock knock, who's there? Banana. Banana who? Knock knock. Well, in the world of law enforcement, that rhyme should always end with knock knock, who's there? The police. We have a warrant. Why? Because State v. Bookman reminded everyone that the police can't just barge into your home like they're late for a Tupperware party. They have to follow the rules, and those rules include knocking, announcing their presence, and waiting a reasonable amount of time before entering. This case illustrated that if officers fail to follow this knock and announce rule, any evidence they find inside might be thrown out in court. So the next time you hear a knock at the door, don't panic. Just make sure to ask, who is it? Before you accidentally invite a SWAT team in for tea and biscuits. We all know cops have a tough job. They protect and serve, often putting themselves in harm's way to keep us safe. But State v. Riddell clarified that community caretaking doesn't give law enforcement carte blanche to enter your home without a warrant. The court emphasized that this exception to the warrant requirement applies only in true emergencies, where there's an immediate threat to someone's safety or well-being. So, unless your barbecue has devolved into a full-blown grease fire with screaming guests running for their lives, the police can't just waltz in under the guise of checking on things. They need a real, demonstrable emergency, and even then, they better be prepared to explain themselves to a judge. We've all had those moments, a gut feeling, a hunch, a nagging suspicion that something's not quite right. But in the world of law enforcement, those feelings need to be backed up by cold, hard facts. State v. Brown reiterated this crucial point, emphasizing that officers can't detain someone based on a vague suspicion or a hunch that something might be amiss. They need specific, objective facts to justify an investigative detention. So unless your spidey senses are tingling because you saw a suspicious bulge in someone's pocket that looks suspiciously like a bag of illegal fireworks, and by suspiciously, I mean you actually saw the fireworks, the police can't just detain someone based on a hunch. They need real evidence, not just a feeling. Otherwise, they might as well start consulting a magic 8-ball for legal advice. In the age of social media, we share everything online. Our breakfast choices, our political rants, our embarrassing childhood photos that should have stayed buried in a shoebox under the bed. But State v. Alessi established a crucial boundary. Law enforcement can't just go snooping through your private messages without a warrant. The court ruled that accessing someone's direct messages requires a communications data warrant, which has a higher burden of proof than a regular search warrant. So unless the police have a warrant specifically authorizing them to delve into your private conversations, your DMs are off limits. It's a victory for privacy in the digital age, reminding us that even in the vast expanse of the internet, we still have the right to keep some things private. Yes, even those embarrassing selfies you accidentally sent to the wrong person. So there you have it, a crash course in New Jersey law, delivered with a healthy dose of humor and just a sprinkle of existential dread. But seriously, folks, these cases highlight the importance of staying informed about your rights. Whether you're a lifelong Jersey resident or just passing through on your way to a Philadelphia Eagles game, knowing your rights can make all the difference in how you interact with law enforcement. Remember, the law is designed to protect everyone, not just those who can afford a fancy lawyer. These rulings are a testament to the power of individual rights and the importance of holding even those in positions of authority accountable. So, the next time you find yourself facing a legal dilemma, don't be afraid to ask questions, stand up for your rights, and if all else fails, well, you could always try quoting these cases verbatim. It might not work, but hey, at least you'll sound impressive. And if you're ever unsure about your rights or need legal advice, remember, I'm not a lawyer, but I play one on TV. Or at least I could if someone gave me a TV show about the law. Until then, stay informed, stay vigilant, and most importantly, stay out of trouble. Or at least try not to get caught.